Mr. Griffith is present with Ms. Thornhill and Mr. Hendry. Mr. Levine is here for the state. Is there anything that we need to take up before the jury comes in?
No, Your Honor.
Judge, I just wanted to remind you that the Oklahoma ruling is very narrow about what can come in, because I anticipate that there will be a witness from Oklahoma today. I don't know if it's a good idea to instruct him before he testifies to be safe.
Who's the witness?
Christopher Hyde, Your Honor.
Is he, do you know about when today he might be testifying?
Yes, either right before lunch or right after lunch, Your Honor.
All right. So when you intend to call that witness, just ask for a break.
Yes, Your Honor.
All right.
The other thing is, I didn't object during jury selection to references to this murder, but I would appreciate that the state not use words that invade the jury's province and imply that the ultimate facts have already been decided, like kidnapping and murder, things like that.
Mr. Levine?
Your Honor, I will be using the words murder and kidnapping. There's nothing wrong about that or objectionable. That's what he's charged with. There's nothing inappropriate about saying those words. Obviously, the jury is here to determine whether he's guilty of those things.
Ms. Thornhill, are you referring, for instance, if Mr. Levine is asking a witness, at the time of the killing or murder, as Mr. Levine wants to say, that it's that type of,
Right.
when he's talking to a witness, not saying things like that?
Not talking about the charges, because of course those are what the charges are, but speaking with, say, a detective and saying, when Collin murdered his mom, when killing is fine, that's fine, homicide is fine, incident is fine, describing facts is fine, but using the words that are going to be, it's going to be the jury's duty to determine whether a kidnapping and a murder happened.
Additional response, Mr. Levine?
Your Honor, first I thought she was referring to opening statement, which doesn't sound like she has a problem, and she should not have a problem with me saying murder or kidnapping opening statement. As it pertains to questioning of the witnesses, if I feel that it's appropriate and there's nothing to the contrary from the court, I don't think there would be anything inappropriate about using those words.
Yesterday he called the
openings.
knife.
You're not talking about openings?
I mean, I would prefer that we keep it more neutral at this point, rather than assigning actions a certain legal description or conclusion that the jury is going to be required to reach, rather than either one of us.
I think that the use of the word murder or kidnapping or anything that connotes a legal conclusion about this killing or these events, depending on how that comes out, the context in which those words are used, I think certainly sometimes that would be a sustainable objection. For instance, if you're asking a witness questions and you say something like, at the time that the defendant murdered his mother, did you know X, Y, or Z, or something like that. I think that is inappropriate and argumentative. I'm a little uncomfortable saying you can't say any of that in opening statements until I hear that. So just be on your toes, Ms. Thornhill, and I'll entertain any objection you have at that time. Of course, openings are not supposed to be argument, so the state needs to be cautious about its word choice in opening statement. But I could envision a circumstance when use of the word murder or kidnapping would be appropriate in opening statement and not argumentative. I think it just depends on how it comes out.
I understand.
So I'll direct the state to avoid using those words in an argumentative context during the course of the trial until closing arguments, especially when questioning witnesses. Do you have any questions about that, Mr. Levine? All right.
And I will say that this arose yesterday because Mr. Levine referred to a knife that was going to be produced in evidence as the murder weapon. So it's that sort of context that concerns me.
Anything additional, Ms. Thornhill?
Just about unsupported opinions being offered by witnesses, things like bragging, unremorseful. We touched on that briefly the other day, just as a reminder, so that I'm trying to avoid me standing up objecting over and over and over.
Again, I think a lot of those things are context specific, and some lay witnesses can give opinions based on everyday observations. For instance, if someone is crying, I think it's appropriate for the witness to render an opinion that they looked sad. But in general, I agree with you that lay opinion, when not supported by common sense deductions, is not appropriate. But you'll just have to cross those bridges when and if we come to them.
I like to say we can jump off that bridge when we get to them, but maybe that's just me being pessimistic.
Anything else?
No, sir.
Mr. Levine, nothing?
No, sir.
All right. Do we know if the remaining juror has arrived?
Yes, yes, they're already sending him up.
They're on their way
They're
out.
sending him.
All right.
Does that mean I have time to take a quick break?
Yes. Counsel and Mr. Hendry, if you tell Ms. Thornhill this when she comes back in. Sometimes lawyers in their opening statements or closing arguments, more often closing arguments, will hearken back to something that someone said in jury selection. If that is in anyone's intention in this case, please do not identify a juror by name. Just one of you or something like that, or if you must identify the person, which I don't know why that would be necessary, use a juror number.
Yes, Your Honor.